Hi everyone, and welcome to today's presentation, Getting Started with IP, Protecting the Look. My name is Fasiha, and I work for the Canadian Intellectual Property Office, or CIPO for short, within the Intellectual Property Awareness and Education team. Today, we are going to review the basics of industrial designs and the reasons why innovators should consider the image that their company projects on the marketplace. Now, before we begin, you might be wondering what CIPO does. IP rights are territorial and are managed by the IP offices of countries around the world. And when I say IP, of course, I'm referring to intellectual property. In Canada, it's us, the Canadian Intellectual Property Office, that is responsible for the administration of most Canadian IP rights. CIPO is a part of the Government Department for Innovation, Science and Economic Development Canada, so we handle application guidelines, forms, and the examinations used in the process to issue patents, trademarks, and industrial designs. We also work on increasing IP awareness among Canadians. As I just mentioned, we work to raise awareness for the effective use of IP by Canadians. To this end, our IP awareness and education program delivers a wide range of products and services, free of charge, that are intended to help Canadians gain a better understanding of the importance of protecting and managing their IP assets. So we are a team of content writers, presenters, and IP advisors who can assist innovators, creators, and entrepreneurs in understanding IP before they engage in conversations with IP professionals, lawyers, or others where their IP will inevitably become a focal point of discussion. So we have many materials that we can explain. For instance, what IP is. We can also help people identify their IP and explain what kind of IP right would be most relevant to various creations. We are also able to explain how to protect their IP and how to manage it effectively, and of course, where to find help. We do all of this either online, through our website, through webinars like today, or even through one-on-one meetings with IP advisors. Again, all of this is free of charge. So in today's webinar, we will start with an overview of IP rights and attempt to answer the following questions. What is an industrial design and what does it protect? What is the concept of novelty? How much does it cost to register a design in Canada, and how long does it take to go through the registration process? We will also explore how it is possible to use industrial design strategically and why it's important for a business to develop a unique look. Today's presentation is, of course, about industrial design, but it's important to have an overview of the other types of IP since they'll come up quite a bit throughout the course of this presentation. So what is IP? IP is all around us. It's in the clothes that we wear, the coffee we buy in the morning, the electronic devices that we use every day, and the music that we listen to on the way to work. Simply put, IP is a creation of the mind. It's actually the form an idea takes when created that can be protected. IP includes inventions, symbols, logos, pictures, designs, literary and artistic works, and many other representations. In business, IP can set one's goods or services apart from others. IP is called property because just like real property, rights are acquired with ownership. Like when you own a building or land, you can sell it, lease it, trade it, and keep others from trespassing into your space. Similarly with IP, you can sell, license, or trade it, and even exclude others from using it. Also, like real property, IP is a valuable business asset. Here on the screen, you see traditional types of IP and the registered rights that are associated with them. So let's take a look at trademarks first. Trademarks are signs that distinguish one's products and services from those of others. They can be a word, symbol, design, or even a sound, scent, or texture. What consumers often see and how they navigate in the marketplace is all a trademark. So it's really about being distinctive so that consumers can easily identify a trademark with the associated product or service and the source of their origin. Now, patents, it's all about functionality, the technical solution to a problem. It's the way you can protect a new or improved product, machine, process, or composition. The invention to be protected must also be new to the world, and useful, and inventive. Then we have the copyright, which typically protects music and artistic creations. Copyright is about original expression, creations that use some level of judgment and skill and are not just a mere copy of another work. Then we have industrial designs, as we're going to go through that today. In more detail, it's what appeals to the eye, unique shapes, patterns, it's all about the look and the aesthetic. Lastly, we have plant breeders' rights, which protect varieties and the denominations of new plants. However, CIPO actually does not manage this application process, and instead it's taken care of by the Canadian Food Inspection Agency. So, IP includes valuable information, and it is important to note that there are 3 other types of IP that exist which hold valuable information but cannot be formally protected. A good example of that is a trade secret. That refers to any business information that derives its value from its secrecy. It can be a method, a technique, any know-how, research, analysis, data, even a customer list or a formula or a secret recipe. It's just some sort of competitive advantage, but that cannot be formally protected. Trade secrets can be very valuable. However, they may not be the best choice of IP protection if your competitors can easily reconstruct or reverse engineer your creation. There are many other examples of non-traditional IP, like domain names and websites, which are not the same as trademarks. Social media accounts that contain a lot of IP, such as trademarks, copyrights, and more, as well as publicity rights. So let's take a look at what an industrial design is. An industrial design is all about how something looks. It's the type of IP that protects the unique appearance of a product and not what it's made of, how it's made, or how it works. Concretely, a design consists of the visual features applied to a finished article. So it must be applied to a finished article, and that feature can be 2- or 3-dimensional. These visual features can refer to shape, configuration, pattern, an ornament, or any combination of these features. Now I'll explain what these different features consist of. In fact, industrial designs can be found in many everyday products. So the features of shape and configuration refer to the 3-dimensional structure of a finished article. So the shape consists of the external form or outline of the object. For example, the shape or external outline of these sunglasses that you see on the screen. The configuration consists of the arrangement of the parts that make up the finished article, such as the different parts of this stool, which is quite original. As for the features of pattern and ornament, they are defined as 2-dimensional elements that are placed on a finished article for decorative purposes. A pattern consists of repeating decorative elements that are all the same, such as the repeated patterns on these hand-woven fabrics. And an ornament is any other decorative element placed on the surface of the finished article, like the ankle patch and eyelids on the side of the shoe, and the black line on the side of the sole. An industrial design can also be comprised of any combination of these features. A cell phone, for example, is a great example of a combination of these features. The unique outer shape of the cell phone can be a design, or the shape and configuration of the cameras are also a combination of features. When the cell phone is turned on, electronic icons appear on the screen corresponding to the menu options. The ornament of each electronic icon could be an industrial design. So the outer shape, the shape and configuration of the cameras, and the ornament of each electronic icon could be registered separately or registered in any combination. I would like to draw your attention to other aspects of these creations that could be protected by other types of IP rights. If you look at the shoe, the Converse sneakers logo, and the famous Apple design on the iPhone, those are both examples of registered trademarks, and the consumers associate these goods to their respective owners. Other elements could be patentable, such as the innovative functions of the cell phone. So keep in mind that more than one type of IP right can coexist in a single innovation. We'll talk about this again in just a few slides. Now, it's important not to confuse how a product looks with how it works. Industrial designs protect only the visual features of a product. As it relates to a finished object, a registered industrial design does not protect how the object was built or assembled, how it functions, and the materials used in the construction of the article. To protect the functional features of a product, such as what it's made of or how it works, you need to obtain patent protection. So if something needs to look a certain way to function, it's not covered by industrial design protection. Now, let's take a look at an example. So can you identify the product related to this specific industrial design that you see on the screen? Well, this is an industrial design for a Pez candy dispenser. Pez candy was created in Vienna, Austria in the 1920s as a smoking alternative. In 1952, Pez Candy Incorporated bought its first Pez candy dispenser to the U.S. and secured a patent. Back in the 1950s, U.S. patents lasted for 17 years. To ensure proper protection for its creation, the company sought various forms of IP protection to safeguard its brand. On the left, you see different angles of a Canadian design registered in 2003. In fact, only the dispenser's base is part of the design. The character's head is excluded. This means that the protection applies only to the base of the dispenser, meaning to the external shape, arrangement of the parts, and the other visual features as they appear on the design. The word Pez was also trademarked by its creator in Canada for the first time in 1951. It's often seen in the form of a drawing, as you can see on the screen. In conclusion, the protection covers the design as applied to the dispenser. A candy dispenser with a different appearance, shape, or ornament could potentially get its own industrial design registration. What's interesting is how the company used patents, industrial designs, and trademarks to protect their products worldwide, including in Canada. Now, what is an industrial design from a legal perspective? An industrial design is a legal claim of ownership. It grants exclusive rights to its proprietor to prevent others from making, selling, or importing an article that includes the description claimed by an industrial design registration. In other words, the registration protects the visual features applied to the object, but not the article itself, and this includes color. You may obtain protection for the design of the entire finished article or part of it, like in the Pez example. In Canada, this exclusive right can last for up to 15 years. A design must also, quote-unquote, appeal to the eye. This requirement is intended to exclude designs where a consumer chooses an article for its utility rather than its visual appeal. The appeal doesn't require an assessment based on its artistic or visual qualities. It must only attract the attention of the consumer. It is recommended to mark your products to show that their designs are registered as an industrial design. The proper mark is a capital letter D inside a circle, and the name or abbreviation of the design's owner on the article, its label, or its packaging. Before going any further, let's take a look at another interactive example. So can you identify which brand is associated with this type of shoe on the screen? These are actually fleece dog's clogs from Double Diamond Distribution, and they're quite similar to Crocs. In October of 2022, the Canadian Federal Court rendered a decision which emphasized the significance of industrial design registration for manufacturers' protection. Crocs initially faced challenges when copies of its unregistered designs flooded the Canadian market. Learning from this, the company adjusted its strategy, and between 2007 and 2009 registered 35 designs exclusively in Canada. This proactive approach proved crucial in their recent legal victory, as the federal court found that one registered design, protecting the Crocs Mammoth trademark sandal, was infringed upon by Double Diamond's Fleece Dog sandal. This case highlights the importance of strategic design registration for effective legal defense in the industry. And one last question before we begin talking about novelty. How many IP rights do you think apply to the Coca-Cola bottle? This one's a multiple choice, and of course, more than one choice could apply. Well, the answer is all of them could apply. In principle, there is no reason why several IP rights may not attach to the same creation. As long as the respective conditions of the protection are met, the IP rights can be enforced by the courts. So let's break down the IP rights related to a bottle of Coca-Cola. First, let's consider the iconic fluted lines of the Coca-Cola bottle. In 1920, the shape and the ornamentation of the bottle was registered as an industrial design in Canada. As the Coca-Cola company invested heavily in promoting its product, the shape of the bottle gained enough distinctiveness in the minds of the Canadian public to be registered as a trademark in the field of soft drink beverages. The Coca-Cola Company also trademarked various iterations of the Coca-Cola word and their signature ribbon design. This word and ribbon design are also protected under copyright law as an artistic work. Next, the bottle cap is an example of a patent. Pepsi, a fierce competitor of Coca-Cola, has patented its bottle cap. It appears that Coca-Cola has not done so. And the recipe is protected as a trade secret, which has proved successful because it is still going strong 125 years after its creation. Now, before submitting your design registration application, it's essential to consider whether the novelty of your design has been preserved. CIPO will only register a design if it is indeed novel, and that means if the design has not been disclosed to the public either in Canada or elsewhere. This novelty requirement implies that any evidence of public disclosure before filing could potentially disqualify the design from obtaining protection. If you have already shared your design with the public, you have a 12-month window to file an application with CIPO if you still want your design to be considered novel. Additionally, it's important to be aware that the 12-month grace period doesn't apply in all countries. In some countries, any public disclosure of a design before filing can immediately prevent the owner from obtaining protection. Moreover, it's wise to take precautions when discussing your design with others before disclosure. Some businesses employ non-disclosure and confidentiality agreements to manage or restrict sensitive information. Always keep in mind that if you intend to seek industrial design protection, your design must be novel. So why should you register your design? Registering your design comes with several important benefits. First, it provides a solid proof of ownership and that you own the design, and ultimately that helps secure your creative rights. Also, by registering the design, you get exclusive rights to make, import, sell, offer, or rent products with your design in Canada for up to 15 years. Registration also provides protection against imitation. So registering your design acts as a strong defense against copycats trying to sell similar products in Canada. As well, by registering, you gain a legally enforceable advantage in marketing and setting your products apart and attracting your customers. Also, your registered design becomes a valuable business asset and potentially opens doors for licensing, partnerships, or even other financial opportunities. In summary, registering your design not only protects your creativity, but it also boosts your competitive advantage and enhances your business's value. Before applying for industrial design protection, you must consider some key points. First, who can apply? Only the person who created the design can apply for registration. If it was created as part of a job, then the employer will own the design. Then, in Canada, it's a first-to-file system, which means that the first applicant gets exclusive rights regardless of when the design was created, so filing early is crucial. You must also preserve the novelty of your design, so keep your design confidential until you register it. If it's been publicly disclosed, remember that you have a 12-month grace period to file without losing protection. Another important step is searching for similar designs. So before applying, it would be a good idea to use the Canadian Industrial Designs database to check if your design is unique. International searches may also be necessary. Remember, your design must be novel in the world. Also, consider protecting in other desired locations. Remember that industrial design rights are only valid where registered, so if you plan to protect your industrial design in multiple places, like in other countries, make sure to register accordingly. Be cautious about sharing your design publicly before registration, as it can affect your protection. And lastly, consider professional help. It might be beneficial to consult with an IP professional for guidance. So preparing and processing an industrial design application in Canada can be quite a complex process, involving knowledge of industrial design law and other office practices. An IP professional can be incredibly valuable in guiding you through this process and offering a range of different services. They can help with a comprehensive search. They can conduct a thorough search of existing industrial designs to determine if your design is truly unique. They can also provide expert guidance. They can address your questions and assist in important decision-making. For instance, they can help you decide whether to protect only the shape, disclaim part of your design, or safeguard the entire design. They'll ensure that your application is well drafted to provide sufficient protection. As well, they can help with prosecution handling. This involves communicating with CIPO, adhering to strict timelines, and making necessary application adjustments. If you are applying to other jurisdictions, an IP professional can guide you through their specific laws and requirements as well. And lastly, they can help with maintenance. An IP professional can help maintain your registration in good standing. So of course, costs for these services can vary depending on your specific needs and the experience of the agent in question. While hiring an agent is not mandatory, CIPO definitely recommends it. In fact, most industrial design applications in Canada benefit from the expertise of an IP professional. So how long do you think it takes to get an industrial design? Well, the time that it takes to obtain an industrial design can vary greatly, depending on factors such as the complexity of the design, the workload of the office, and the number of amendments or objections filed during the examination process. To give you an idea, the current service standard on CIPO's website is 21 months for a first action. This means that it takes approximately 21 months from the moment you submit your application until the examination of your file. After examination, your application will either be allowed and then processed to registration, or you will receive an examination report outlining the examiner's objections to registration and indicating what information you still need to add or what relevant changes need to be made to your application. At the moment, the registration of a design takes nearly 2 years. Let's try to answer this question by looking at the fees in the following table. Now, how much does it cost to obtain and maintain a design in Canada? Let's try to answer that question by looking at the fees in the following table. To begin, you need to pay a fee when you submit your registration application to CIPO. This year, the filing fee, including the examination of your application, is around $430. Then you will have to pay for what is called the maintenance fee within 5 years from the date of registration in order to keep your design active for up to 15 years. The maintenance fee for that is currently about $375. There are also some other possible additional fees, including the advanced examination fee, which is paid if you want your application to be examined more quickly. This also includes the reinstatement fee, which you'll only have to pay if you miss a deadline, like being late to pay a fee or respond to a letter from the office. It also includes the delaying of a registration fee. So this would be paid if, for example, you want to hold off on registering your design, perhaps to ensure that your product is ready to launch at the same time. So in the end, the administrative fees for registering an industrial design can vary depending on your situation, but you will need to pay the filing and maintenance fees, which are approximately $800 combined, if you submit your application by the end of the year. Please note that the fees are adjusted each year, and as you can see on the screen, the fees will increase significantly starting January 1st, 2024. The table on this slide illustrates that similar rights may be acquired on a country-by-country basis, but there are differences between countries. For example, the names are slightly different, and interestingly, the equivalent of an industrial design is known as a design patent in the United States. It's not a coincidence that it's called a design patent. Similar to a regular patent, it needs to be unique and kept secret until you can apply for protection. Also, the protection period varies from one country to another. In the United States, just like in Canada, the term of a design patent is 15 years from the date it was granted, and in the European Union, a community design, as it's called, is valid for 5 years and can be renewed for up to 4 times for a total of 25 years. Taking into account the differences both on screen and in terms of laws and practices, it's important to consult an expert in the country in which you intend to secure protection. I'd also like to note that it's possible to file an application through the Hague system, which is also known as the international route. Using the Hague system, you may be able to protect your design in multiple countries at the same time, and this includes Canada. Now, let's take a look at why developing a unique look truly matters from a business perspective. Firstly, it's the impact for a company image on consumers. So as a consumer, when you enter a marketplace, what's the first thing you notice? What grabs your attention? Which products and services do you head for and consider buying? The next is the power of first impressions. A company's image, its unique appearance, can profoundly influence consumer perceptions. Products and services are presented in a way that attracts and convinces buyers that they are what they need. While quality is essential, the initial attraction is of course visual, and combining quality with a distinctive look can create a positive first impression, fostering trust and loyalty. Next, an industrial design is where look and function meet. So let's revisit the presentation title. It's called Protecting the Look. Industrial design revolves around aesthetics. We aim for designs that are both distinctive and visually appealing, but we also want form and function to harmonize, resulting in products that are user-friendly and practical. As well, the strategic use of IP makes for a memorable brand image. Therefore, it's crucial that companies develop a unique brand image that consumers can remember. Intellectual property rights, when strategically used, can help a business achieve precisely that. So in summary, a company's appearance greatly influences consumers, and creating a lasting brand image can be enhanced through the strategic use of IP rights. So, how can you use industrial design strategically to have this impact and create a memorable image in the eyes of the consumer? A first example could be to align the design with the technology. Think about the consumer electronics like smartphones. Some people like phones that look sleek and stylish with unique icons on the screen. Elements like this can be protected with industrial designs. Others want technical items in their phones, like wireless or built-in speakers. These can be protected with patents. So why not combine the distinctive looks and the technical features right from the beginning? By working on both patents and industrial designs at the same time, you can make products that are easy to use and work well, but also look fun and stand out to customers. The Dyson vacuum is a great example of a combination of patent and industrial design protection. Another way to use your industrial design strategically is to use both trademark and industrial designs on the same object. In business, sending the right message and having a distinct image is essential. If people can't recognize your products or services, they may choose to work with someone more noticeable. As I explained in the beginning of this presentation, trademarks are used to distinguish one's products. They are a source indicator. An industrial design, on the other hand, protects the unique visual features of an article, including its shape, patterns, or ornaments. It's basically the way that an article looks. So why not take advantage of both? The visual appeal provided by the design and the reputation and fame bought by the trademark, indicating the origin of these products, and in other words, who produced them. Adidas registered a design a long time ago in 1971. Those 3 bands applied to a pair of shoes became famous over time. The company has also registered trademarks including the 3 marks showed on screen. Whether they are affixed to a pair of athletic shoes or baby shoes, Adidas's trademarks and designs work together to enhance the company's reputation. This is a great example of the strategic use of 2 types of IP rights. Over time, people come to associate the brand with the visual appeal brought about by the unique nature of the registered industrial design. You can also associate industrial design with another type of IP to enhance the consumer's perception of the product's quality. For instance, adding a geographical indication to a product signals to customers that it is of high quality. Consider the geographical indication Canadian whiskey. It informs consumers that whiskey is made in Canada. Crown Royal whiskey, produced in Canada, serves as a really good example of this. It has acquired a distinct identity reinforced by the recognizable design of the bottle. The Crown Royal whiskey bottle itself has also become famous and is registered as an industrial design due to its special and unique shape. So when customers purchase Crown Royal whiskey, they immediately recognize the bottle and consider it a symbol of high-quality Canadian whiskey. You can also use industrial design strategically by protecting the visual characteristics of an article with an original artistic work. A good example is copyright applied to a finished article, so potentially to a registered industrial design. A design printed on a board game is likely eligible for copyright protection as an original artistic work. Additionally, if the board game design is novel, it could qualify for industrial design protection, and it's the same idea with the drawing on this service tray that you see on the screen. By now, you know that industrial designs can be protected as a type of intellectual property, but that they are also an activity that can be an integral part of a business. Design, whether it's how things look or work, can be a key part of your company's identity and give you an edge in the market. Many different types of designers exist, and if businesses realize how important designs are for their products, services, and reputation, they can create more job opportunities. To make this happen, product designers, graphic designers, and tech experts should work together to come up with practical and more unique ideas that balance both style and function. It's also crucial to understand what consumers want and need in terms of how products work and how they look. When a company invests in design, it can create a distinct and appealing image that helps attract customers and stand out from the competition. So we've learned that IP significantly influences how consumers behave and view brands, and that industrial designs are often overlooked, yet they play quite an important role in a business's success. Consumers seek novelty, quality, and competitive prices in today's market. IP rights and industrial designs play a crucial role in making products appealing and functional, and overall enhancing brand popularity. In the end, selling great products, giving customers an exceptional experience, and maintaining consistent design all build trust with consumers, forming strong and lasting relationships between the brand and the consumers. In conclusion, our discussion has shown the importance of industrial design and other IP rights, and that they are important and influence how people shop and perceive brands. This connection between IP and brand success is especially crucial in the context of industrial design, as highlighted in the presentation Protecting the Look. By safeguarding unique designs, businesses can build stronger connections with customers and have a greater impact on their audience. So, to quickly sum up the key takeaways, an industrial design is about how a product looks. It consists of features of shape, configuration, patterns, or ornaments, and it's when all of these are applied to an article. To be registered, a design must be novel in the world, and searching industrial design databases to find identical or similar designs to you is crucial. Industrial designs and other IP rights can coexist in a single innovation and contribute to creating the unique look desired by consumers. And lastly, industrial design registration creates value for your company. All of the resources, materials, and tools that I've talked about contain a wealth of useful IP-related content and are available in different formats such as audio, video, text, and interactive. Like I said, although we are happy to guide and give you as much information as possible on IP rights, we cannot provide you with legal advice. All of the questions that you see in this slide are unfortunately questions that require a legal opinion. You might also require help in understanding complex topics, obtaining legal advice in case of infringement, or seeking an opinion on strategic positioning and searching advanced databases. To that effect, there are groups and associations of IP professionals that you could turn to. To locate a licensed IP agent near you, you can contact the College of Patent and Trademark Agents, or CIPO, which is the newly formed organization responsible for the management of IP agents. We recommend that you only deal with IP agents that are on the CIPO list of registered IP agents, as these are individuals that have passed IP-related exams, are regulated and disciplined by the CIPO. There are unfortunately individuals out there who will pose as an IP expert while they do not have the required credentials, so it's important that you stay diligent and that you consult the CIPO website to make sure that you know who you are hiring to assist you with your IP rights. The Intellectual Property Institute of Canada, or IPIC, and the Bar Association are professional associations where you can find a lawyer or IP professional as well. Please do not hesitate to contact us if you have any further questions or need help finding our resources on our website. You can reach us via the contact information that you see on the screen. You can also contact our intellectual property advisors for a more specific and tailored discussion to your needs by scanning the QR code that you see on the screen. And for general inquiries and questions about intellectual property, please feel free to reach out to our customer service center by either phone or email. The toll-free number is also provided on the screen. Lastly, I invite you to follow us on social media. We are on Facebook, YouTube, LinkedIn, and X, and I recommend exploring the CIPO newsletter titled IP for Business News, where you can find information about new IP products, seminars, webinars, upcoming events, updates to the CIPO website, and more. So this concludes our presentation for today. I hope you have learned more about industrial designs and have enjoyed this presentation. To learn more about the other topics discussed, I invite you to watch our other videos, and you can also register for live webinars on our website. Thank you so much for watching.